Welcome to the second episode of Beyond Retirement Learning Series. This is sponsored by Senior Edge Legal, and I'm Susan Graham, the owner of that business. I'm a certified elder law attorney located in Boise, Idaho. Today's topic is going to be estate planning strategies, and this will last approximately 20 minutes. Now, I know your purpose is to learn some information and to think if I might be a good person to put on your team. And my purpose is to give you useful information to help you have a secure future. In addition, we have free forms available for you, and I encourage you to take advantage of that. And lastly, I will show you a way that you can meet with me at the end of this meeting. Anytime that you want to, you can click at the bottom of this page an evaluation form, and that will provide you access to those free legal forms and information on how to get in touch with us. In the first episode, we talked about the 3 pillars of estate planning. The first pillar being figure out what your current situation is, and then coming up with goals for the rest of your life. The second pillar was actually coming up with a plan, but the third pillar that we addressed in that first meeting was actually implement your plan and keep it up to date. So today we're going to talk about estate planning strategies. Now, if you have no plan in place, the government has a plan for you. It may not be a plan that you particularly like, and you may not even know what that plan is. But for most people, that's their most common choice. Over 50% of the people in this country have no estate plan in place. So what does that mean? What that means is if you die and you're a single person, you look to the state law to figure out how things are going to be distributed and who's going to be in charge. In Idaho, what that means is the person who's in charge, that's called a personal representative, that individual will have to petition the court and ask to be appointed to be able to handle your affairs. This all comes down to who has the power to sign on behalf of a dead person to access those titled assets and ultimately see everything is handled properly, pay the bills, and distribute things out the way they're supposed to. So under the Idaho Code, if you have no plan in place, as a single person, there's a priority, and it comes down to your kids or some other family members, and ultimately your creditors if there's nobody who you've nominated under a will. Even more important is who actually gets your property. Again, under the law that's been adopted by the Idaho legislature, if you have no plan in place, then of course all the bills need to be paid, but then everything will be distributed equally among your children. And if a child dies before you, that deceased child's share will go to their children, your grandchildren. And the law says, by the way, they're grown-ups at age 18. So if somebody's young, you don't know, under 18, you don't know who's going to manage the money for them. And then once they're 18, they get the money outright. There are studies done. I don't know why anybody bothers to do a study for this, but there are studies done that show young people are idiots until their late 20s, even though the law says they're a grown-up at age 18. What I'm talking about is when you have an 18-year-old that has no experience on how to handle money, usually they regard this as having won the lottery, and they don't have much money left. They actually competitively spend that money for a car, for a wardrobe, for a sound system, for silliness things. If you have no children and you have no estate plan in place, then everything will go to your parents. And if your parents are gone, it'll go to your siblings. And if none of those people exist, we go up to your grandparents and so forth through your family line. If you truly are an orphan, then the state of Idaho Department of Education will get those funds. Now, they could probably use the money, but if you really want it to go that way, it'd be a lot simpler to do this with a proper written estate plan. If you're married and you have no plan in place, the Idaho legislature, again, has come up with a plan for you. This is a community property estate. There are a number of other community property states in the nation, although the majority of the states are separate property states. What that means is that the presumption is all the property that you have, you and your spouse, belongs to the both of you. And it's only divided when the marriage is over through death or divorce. So we're only talking about death. So when somebody dies, if everything they own is community property, then it'll all go to the surviving spouse. It doesn't matter whose wages earned that property, and it doesn't matter how that property is titled. So that's the presumption of the property owned by married people. But there's another kind of property called separate property. That's something you owned before the marriage, or you received as a gift or an inheritance to just one spouse. What the law says, again, if there's no plan in place, that all of the separate property, not all, half of the separate property goes to a surviving spouse, and half of that property would go to the children of the deceased spouse or perhaps to the parents. So that's the plan in place. If you die and you have no plan, the government has that plan for you. In addition, what if you become incompetent? What if you're mentally or physically can't handle your affairs? Who is actually going to handle those for you? What we're talking about is who can sign, again, on behalf of an incapacitated person to access those assets. The person who can do that would be someone who actually has to petition the court and say, hey, judge, I need to do something to help handle these affairs, these finances of the incapacitated person. So how do we do that? How do we select that person? Now, if you've been married for a long time, it's pretty easy to
Stop.
No, that's... Sorry, I was going to sneeze, so I think I caught it. Anyway, if you're married, oftentimes, I was married to a nice man, and he went off to the Vietnam War. Then we were married for a couple of months before that happened. I knew how to forge his signature before he left. I mean, you do some of those things just because you have to. Well, that's not really a good way of handling affairs for somebody who's incompetent, especially if you're going to try to sign a deed transferring the real property to the healthy spouse or transferring the property to a buyer because you need to sell the house to be able to pay the bills for the two of them. So you need to then petition the court and say, hey, judge, I want to be appointed as the conservator and the guardian for my incapacitated spouse. The conservator is the one who handles the money, and the guardian is the one who makes the health and housing decisions for that incapacitated person. So when you do that, it's necessary for the petitioner, the spouse, or maybe it's a child there is no spouse and the child is willing to step up, or another family member or a friend. But anyway, that individual will hire an attorney. And the court automatically then will appoint a different attorney, even if you've been married for 50 years. The different attorney will be appointed to represent the incapacitated person. In addition, there will be somebody called the visitor. This is often another attorney who is appointed by the court to go and talk to everybody and make a recommendation to the court for what they think is the best for the incapacitated person. Lastly, there's a doctor who has to do an evaluation of that person. Now, all these four professionals submit their reports to the court. And there's a hearing, usually at the fastest, it's about 3 months before a conservator and guardian will be appointed, although a temporary one can be appointed in the meantime. These proceedings usually cost $4,000 to $5,000 in our county, and sometimes more, sometimes less in different places. And that assumes it's not contested. In addition, whoever gets appointed has to file at a minimum once a year a report with the court saying what's happening with the money that's associated with that incapacitated person and how's their health, what's their condition. So that's a conservatorship and guardianship proceeding. That's what happens if you have no estate plan in place. So let's start coming up with some ideas that actually improve this and make you, the person who's planning, have a more secure future. One of the first things you can do is you can sign a financial power of attorney and a health power of attorney and a living will. And those are the forms that we have available at no charge. So again, click that button at the bottom and follow the instructions, and those forms will be made available to you. The financial power of attorney is a document that you sign that says if who can sign on your behalf to do checks and do modest business on your behalf. That document needs to be signed in front of a notary public. In addition, you'll select a first person, and you may have some alternates to have in case that first person is not available. There's another critical document that's called a living will and a health power of attorney. The living will is a document that says if a doctor says you're going to die soon, that you have a terminal illness or condition, and that your death is imminent, or that you're in a persistent vegetative state and you're not going to be coming out of that coma, you get all the pain pills you want and 3 choices. The first choice says use everything in science and medicine to keep you going as long as possible. The second one says, no, skip that stuff, but do give me nutrition and hydration with tubes. And the third one says, don't even bother with that. Just keep me comfortable and let me go. I have done thousands of these. I will tell you that the most common choice is the third one. But it doesn't matter. You choose whatever one you want. In addition, there's a companion document called a durable power of attorney for health care. And this says who's going to talk to the doctor when you can't communicate effectively. You're not going to die, but maybe you're in a coma from a car wreck, and you're going to be in that coma for a couple of days, and you've broken your collarbone in the meantime. So who's talking to the doctor to make those health decisions about that care? And again, you want some alternates. Those documents need to just be signed. You don't need to have those notarized, although the financial power of attorney needs to be signed in front of a notary. I would encourage you, when you sign those documents, to give a copy to the people you're naming as your agents so that they have that copy. And you might let them know where you keep the original. And give a copy of the living will and the health power of attorney to your physician. So that's one set of documents that everybody needs in their planning process. Now, there are other documents, of course, a last will and testament. A last will and testament is a formal document, and I would encourage you to have this done with an attorney. The reason I say that, I know there are forms on the internet, but the problem is you're never going to know if it's done properly until you're dead. And this is a little late because you can't fix it then. So that's why I strongly encourage you to have an attorney do this for you. What you're going to say in that last will and testament is who's going to be in charge. We call them personal representative, but they're also called executors. And you also, to sign a will and have it be valid, you need to be over the age of 18, and you need to be of sound mind. That means and that's not a real high standard. That means you need to know what the approximate date is, where you're living, who your family is, your immediate family, what do you own, and what the approximate values of that. You really don't even need to know who the President of the United States is. What you're also going to say in that last will, besides naming your personal representative and an alternate to that personal representative in case that individual is not available. And by the way, if you don't have anybody to put down, that's useful information, as we discussed in our first episode of the Beyond Retirement Learning series. There are professionals who can serve as personal representative. Bank trust departments, sometimes your CPA or your attorney will do that, or there are other professionals who can serve in that slot. Then you're going to refer to a list of who gets what I call the stuff. That means who gets the rug, who gets the ring, who gets the gun. And you don't have to put it in detailed inside the will. It can be a separate document. You're going to say if you have a specific distribution to give, the cabin to someone, you put that down. And then after that, you say everything goes to, could be your spouse, or it could be your children. Then you're going to address, what if somebody predeceases you? If they die before you, who gets that person's share? And lastly, if you have young people to whom you're giving property, you may want to include language that says the money's going to be managed for them until they're older. As I mentioned before, young people really have a hard time figuring things out. And so it's useful for many families to say, no, the money's going to be managed for them until they're 30. Doesn't mean they won't have access to that money. You get to choose who's going to manage it for them. Could be used for paying for schooling, could be used for paying for tutors, the down payment on a home, for buying a car, for starting a business, whatever you decide. But then oftentimes they get the balance of the money at 30 or some other age that you think is appropriate. Then the will needs to be signed and witnessed and notarized for it to be valid under the Idaho law and in most other jurisdictions. So that's what you say in a last will and testament. Then when you die, if you have a will in place, The government's not deciding how things are going to be. You get to decide. And so that whoever you've nominated as personal representative will file a petition with the court and say, hey, judge, appoint me as the personal representative and give me the power to sign on behalf of the dead person. Now, this will has to be probated. You can't just wave it around and, so you're the surviving spouse and you go to a real estate closing and the house is titled in both names. You can't, again, forge your spouse's signature on that deed. It's going to be signed in front of a notary public. That will never work. And if you just show the will and say, see, I'm the spouse and I get everything and I've been named as personal representative, let me just sign, they're going to say no. You're going to have to go get an order from the court because the real estate people are not judges. They don't know whether this was the last will that was done. It could have been other wills were done. They don't know if the will was technically done right. They don't know if the person who signed it was competent when they signed the will. They don't know whether they were under undue influence. That means somebody was twisting their arm and saying, you have to sign this document naming me as personal representative and giving me all the property before I let you out of the basement. So even though you have a will that says where the property is going to go and who's going to be in charge, that will still have to be probated in the local probate court, the court in which that person died and was a resident. Now, for married couple, there is another document that can be signed that would avoid the probate. If you want everything to go to your community property spouse, to all of the property, the separate and community property to go to your spouse, and you don't want to probate it, and you own no land outside the state of Idaho, you can sign a contract that says, I give everything to my spouse, and include the legal description of the property that you own. Lot 2, Block 10 of somebody's subdivision. You record that agreement in the county where the property is located, and if you own property in a different county in Idaho, you would record it in that county as well. Then when somebody dies, all you do is the surviving spouse gets a certified copy of the death certificate and record that with an affidavit in those two counties, and that will clear the title to the surviving spouse. So you get to avoid the death probate. That document's called a devolution agreement or a community property agreement. Now, the other thing that you can do and by the way, if you have a car wreck and you're in a coma, that will doesn't do anything to avoid the conservatorship and guardianship proceeding. And it may be necessary to still go to court to have someone appointed as conservator and guardian because those financial powers of attorney are not always accepted. The law in Idaho now says that a bank or another financial institution has to accept that power of attorney, and if they don't, they can tell you in 7 days why they won't take it. Well, after that law went into effect about 10 years ago, one of the local banks said they wouldn't take them. And so it would be necessary to sue the bank to make them take that. And that's crazy. You're going down some rabbit hole, you don't know where that's going to go. So oftentimes, even though they should take the powers of attorney, it's still, even if one exists, it's still necessary to go through a conservatorship and guardianship proceeding. One last thing I'm going to address today is doing a beneficiary designation on life insurance, retirement accounts, and annuities. So you can do that, and that would avoid probate, the need to go to court and hire an attorney to go through that whole process. You need to pay attention. If you've used beneficiary designations, again, name an alternate in case that first person dies, and pay attention. Is the person who's supposed to receive the property a minor? If so, you really don't want them to get the money because you don't know who's going to manage that. Or are they under 30? Or are they having financial problems? Again, pay attention. It may not always be the best to just rely on a beneficiary designation. Also, you could make bank accounts or certificates of deposit, paid on death accounts or transfer on death accounts, TOD accounts or POD accounts, and that too will avoid a death probate. And if you're going to use that approach, again, name a contingent, someone else in case that first person's not available. I've addressed some of the planning strategies, but there are others. Revocable trusts, irrevocable trusts, asset protection trust. I'm going to address those in our third episode. Right now, I'd encourage you to click that button at the bottom of the page and fill out that evaluation form telling me how I can improve, what topics you would like in the future. And if you would like to meet with me, just indicate that and someone will contact you from my office, ask a few basic questions to see if we have a potential for being a good fit. I want to thank you so much for listening to this today. Thank you.